बताओ भाई। 1800 रुपये की है। हाँ तो कैसे? 200 रुपये कनेक्ट कर। कैसे?
Principal ma'am, may we proceed? Right, ma'am. Good afternoon, ladies and gentlemen. As the clock strikes 1:30 p.m., we mark the auspicious moment of culmination. The curtains may be drawing on the 3 dense intellectual rigor and dedication to the pathway of resolution, but the lessons learned and the connections forged will resonate long after. I am Mansi Gupta, Assistant Professor, Convener of the event. On behalf of Department of Law, Prestige Institute of Management and Research, Gwalior, extend a heartfelt welcome to you all. We are deeply honored to welcome our luminous constellation of dignitaries to the valedictory session. Senior Advocate Pradeep Rai sir, Advocate Devrat sir, Professor Dr. Rakhi Singh Chauhan ma'am, Principal Department of Law PIMRG, my esteemed colleagues, all volunteer participants. Your gracious presence adds profound to this academic celebration. Every noble endeavor requires wisdom and enlightenment, especially when the complex pathways of laws. Dedicate a few moments to seeking divine guidance and invoking Ma Saraswati, the goddess of knowledge, to bless this occasion. Please join us in a moment of reverence as we share the sacred Saraswati Vandana. Thank you. May the light shine upon the paths of all our participants. An institution's vision is the compass that guides its journey towards excellence. We are fortunate to be steered by a leader of exceptional acumen and foresight. I now invite the driving force behind this entire endeavor, the inspiration and guiding light for all of us, Professor Dr. Rakhi Singh Chauhan, ma'am, Principal Department of Law, PIMRG, to address the gathering. Ma'am.
Shri Advocate Pradeep Rai ji, Shri Advocate Devrat ji, dear faculty colleagues, dear parents, and my very dear bachon, a very warm good afternoon to all of you. It's truly a moment of pride for us as we conclude the National Arbitration Competition hosted by our college. Over past few days since 20th November, we have witnessed intense arguments, brilliant submissions, and remarkable advocacy skills which were demonstrated by students from across the country. Each one of you has shown knowledge of law and spirit of true legal professional. So arbitration is no longer just an alternative to litigation. It is now becoming the first choice. So whether it is commercial dispute, whether it is cross-border disagreements, may it be international trade issues, construction contracts, may it be corporate conflict, arbitration today stands as a vital pillar of modern dispute resolution. The world is moving towards mechanism that guarantees speed, that guarantee confidentiality. It also must be cost effective and it must have the expertise. All of these things are being provided by us. So for young law students, this field is not only promising, but also with immense scope for becoming arbitrators, counsels, drafters, mediators, and other institutional professionals. So if there is a sunrise sector in law today, it is arbitration and ADR. I am really wanting to tell you one incident that when I was posted in Chandigarh, in our institute, there was a litigation which was having an arbitration clause, and the tribunal was lying in Dehradun. The litigation dispute was just of 23 lakhs. And when we were searching the lawyers, we contacted the arbitration lawyers. The minimum amount that was quoted by the lawyer was 5 lakhs for the dispute of 23 lakhs. And since then, it was bugging my mind that why not our law students learn the skills of advocacy in arbitration? Why not they come in mainstream of arbitration if this is a so promising career, and that too global? And therefore, this was our purpose behind hosting. It was an initiation, it was on trial, and accordingly, we got a good response. We are expecting far more good response next year. And this was our purpose behind hosting this competition. That when we conceptualized this national arbitration competition, our vision was very, very clear. It was to develop the argument skills of students in the context of arbitration. It was to help them understand the procedure and practical nuances. It was to familiarize them with drafting submissions, rebuttal, and everything which happens in arbitration tribunal. And above all, to prepare them for the new age of dispute resolution. So this competition was not merely a contest, it was a training ground. The confidence which participants choose, identified their legal positions, and presented their arguments, that reflects the objectives which we framed was truly fulfilled. And a small message to participant today I want to give, that whether you win a trophy or not, remember, by just participating, you have already won. You have won an experience that will benefit you in your entire life. So this exposure is priceless. I congratulate everyone for their commitment, learning, and excellence. And I'm grateful enough to have given plenty ample of time by judging the competition, and they graced us here. Thank you. Thank you so much. Jai Hind.
Thank you so much, ma'am, for those insightful and motivating words. Before we move forward, it is essential to reflect on the intensive 3-day journey we have collectively undertaken. I now invite my diligent colleague and convener of the event, Akshay Bhargava sir, Assistant Professor, Department of Law, PIG, to present the official report of the competition. Sir?
Thank you very much, Mansi ma'am, and a very good afternoon, respected principal ma'am, honorable judges, participants, dear colleagues, and the students. I, Akshay Bhargav, faculty convener and assistant professor, Department of Law, Prestige Institute of Management and Research, Gwalior, takes privilege to present the report on this prestigious arbitration competition. This report presents a comprehensive factual overview of the Prestige National Arbitration Competition 2025, including participation statistics, round progression, judging paneling, and milestones of the event. It is neutral, administrative record style document intended to summarize the conduct of the competition from the preliminary rounds to the final rounds. This competition was done under the constant support and guidance and the encouragement of our respected principal ma'am, Professor Dr. Rakhi Singh Chauhan ma'am, whose leadership made this successful conduct of event and this competition a possible one. So coming to the rounds, a total of 22 teams registered from the various reputed law universities across India, and their competing authorities made them possible to compete through the multiple rounds. Moving forward, the competition was entirely held in the online mode, ensuring the accessibility, transparency, and uniformity. All teams argued from the both side, claimant and respondent, in the preliminary round, and preliminary rounds were adjudicated by following respected advocates. The first one, Advocate Ujjwal Sharma sir, Advocate Geetika Jain ma'am, Advocate Mehul Bansal sir, Advocate Tofel Sharif sir, Advocate Akarshi Jain ma'am. Based on the aggregated scores of preliminary first and second round, 4 teams qualified for the semifinals. The semi-final rounds were adjudicated by Advocate Amit Bedi sir, Advocate R.H. Sikandar sir, Advocate Ankita Sharma ma'am, and Advocate Sandeep Jindal sir. These judges evaluated detailed legal reasoning, mastering of the arbitration problem, time management, persuasiveness, and depth of statutory and case laws knowledge. The final represented the culmination of the weeks of rigorous preparation of the participants, the final rounds, which was adjudicated today by two of our eminent legal luminaries, the senior advocate Pradeep Rai sir and advocate Devras sir, Ewar sir. Both judges brought exceptional experience from arbitration, commercial dispute, and courtroom practices, ensuring a high standard of final evaluation. The top two teams presented their oral submissions and arbitration proposition concerning the Urban Developers Private Limited and Greenwood Infrastructure LLPs. The competition tested drafting, argumentation, research, and arbitration skills. The arbitration problem involved complex issues of contract performance, BMS integration, ESIC liability, Consumer Protection Act implications, and corporate governance. Judging panels included senior advocates, arbitration experts, and commercial law practitioners. The entire event was executed smoothly in the online mode, and the prestige National Arbitration Competition 2025 was successfully fulfilled its mission of promoting excellence in the arbitration advocacy and legal research among the law students across India. Across 4 rounds, the judging panelists ensured rigorous evaluation while encouraging professional growth among participants. The competition upheld fairness, transparency, and academic integrity throughout, serving the premier national platform for budding arbitration councils. So, thank you everyone for this taking the part in this completely aspect. So, thank you so much. Over to you, Mansi ma'am. Thank you.
Thank you, sir, for that comprehensive report. It is now my distinct honor to personality whose own career is a masterclass in legal resolve and constitutional wisdom, Advocate Devrat Rai sir. Sir is not just a lawyer, he is a distinguished advocate on record at the Supreme Court of India, bringing with him over 22 years of dedicated practice. His professional journey embodies a rare blend of experience, depth, and versatility. His practice is a panoramic view of India's highest courts, spanning the Supreme Court of India, High Court of Delhi, the Central Administrative Tribunal, and numerous other specialized tribunals. His strong foundation, rooted in both commerce and law, been meticulously refined through decades of handling high-stakes litigation. In a sphere highly relevant to this competition, Advocate Devrat sir is a certified senior mediator at the Supreme Court Mediation Center. He does not just argue disputes, he resolves them. He has successfully mediated complex business and personal conflicts, bringing clarity, neutrality, and decisive resolution-oriented leadership to the table. His core areas of expertise showcase his comprehensive understanding of the law. His service to the legal institution is equally noteworthy. He has served as the secretary of the Supreme Court Advocate on Record Association and gained invaluable jurisprudence from his early association with the late Sri T.R. Ande Rujina, former Solicitor General of India. He served as Central Government Counsel before the Supreme Court for over 14 years and has successfully appeared in over 550 cases, contributing numerous landmark judgments reported in SCC Supreme Court cases. With this distinguished record, unmatched experience, and a grounded approach, Advocate Devrat sir truly stands as an exemplar of professionalism and service to the law. Dear participants, please join me in extending the warmest and the most enthusiastic welcome to Advocate Devrat sir. Sir, we are honored to have you and we eagerly await your address the gathering.
Thank you very much, Mansi ji, for that detailed introduction. And your competition has really educated us all, including the students, I think the faculty and everybody, even we had to brush up our knowledge a little in order to, be abreast with the recent laws and all. So, Pradeep Rai ji, my esteemed colleague and senior in Supreme Court, Dr. Akhi Singh, Dr. Akshay Bhargav, uh, Mansi ji, Mansi Gupta ji, and Ashi Mangal ji, who has assisted us all through with her direct inputs on email as well as on WhatsApp, on call, her illuminating video which she sent, introductory video, which I saw today in order to acquaint myself with the procedure. Anirudh Gupta, the secretary, and I think he's the student wing secretary, if I'm right, and all the distinguished faculty and students, whoever are online watching this competition, all the learned judges who have been with us in this journey, the young colleagues who are at the bar, who have joined this presentation, and and all the participants who have enriched the competition with your intellect and dedication. It is both privilege and responsibility to address you at the conclusion of what has been undoubtedly been an enriching journey for all the participants. As someone who has witnessed the evolution of the arbitration practice in India's highest court, I can tell you with certainty you have chosen to invite your time in learning a skill that will define a dispute resolution in the decades ahead. Like in the beginning, when I was called to address, I said that it's a field which is quite paying, unlike other litigating field where even we are practicing. This is quite rewarding that way, and it's a ever growing field, one of the most prestigious in alternative disputes resolution system, and you are going to benefit from it. So let me begin with a number that should matter to every young lawyer in this room. India currently has over 5 crore pending cases across its judiciary. The commercial court alone saw addition faster than disposals in the recent years. This isn't just a fantastic statistics. It represents businesses which are in limbo, because of the disputes. Contracts which are shrouded with uncertainty and economic value trapped in litigation. So you can gauge that how important the arbitration is. Justice R.F. Nariman in Sangyong Engineering 2019 case, he has observed, I'm just reading it, that 2015 amendments to the Arbitration and Conciliation Act were meant to minimize judicial intervention and ensure that arbitration becomes a preferred mode of settlement. This wasn't mere judicial observation, I would say. It was a clarion call for transformation in how we resolve commercial disputes in India. And as we know, Justice Nariman was an expert in arbitration and commercial laws, so his words carry a lot of weight. Arbitration isn't merely an alternative to this congestion of legal cases, I would say. It represents a fundamentally different philosophy of dispute resolution, one based on party autonomy, commercial sensibility, and the recognition that justice delayed in commercial matter is capital destroyed. In the interregnum of your 2 sessions, I had a client in between, which I mistakenly gave a time, in between your sessions. So he was waiting. So what has happened that he has, I'm just telling you a real life, problems. He has just given me this huge dossier of his cases and all. This is gone. So this man has invested some 10 crores, and there is an IFC venture capital, which gives credit to certain sections of the society. He came from Uttarakhand. So they promised him a loan of maybe 15 crores, something like that. They sanctioned 5 crores, then they stopped the loan. Now he has some 4,000 square yard of land in Haldwani, which is stuck. He is not able to go forward. He is not able to go backwards because his building is half done. The funding has been stopped. He will be stuck in litigation now. So if there is an arbitration and the IFCI, if they agree, they should either fund it or say that they are not going to fund it. Because this is IFCI financed thing, no bank will come forward to finance it. And at that, interest rate, which is quite low, which IFCI has promised. So these kind of, disputes actually log jam the progress of the country. In a prime place in the city of Haldwani, which is growing now, even the High Court, Uttarakhand of High Court is coming up there. So if you, occupy such a huge land, and from 2017 it started, 3 years, nothing has been done. So, the wastage of resources which is going to take place. I just gave you a, real life example where the arbitration can be really useful and save a lot of time and effort of litigation. India has a long arbitration journey, not like other countries which are developed countries, but even we have progressed a lot in the arbitration. Our journey hasn't been without challenges. The infamous Bhatia International Doctrine once allowed Indian courts to exercise supervisory jurisdiction even over foreign seated arbitrations, an overreach that made India's arbitration averse. The legislative correction in 2015, validated by the Constitution Bench in Balco's judgment, this was 2012 judgment, was crucial when the court in Bharat Aluminium finally laid Bhatia International Judgment to rest. It signals India's maturity as an arbitration jurisdiction. Similarly, the TRF Limited case in subsequent 2019 amendment removing the automatic stay on the enforcement pending challenge represented India shedding its pro-litigation mindset, which was very important, in my opinion. These weren't just legal reforms, they were philosophical shifts also. Like I read Justice Nariman's, he has contributed a lot in development of arbitration law. The establishment of Niti Aayog's Committee on Institutional Reforms in Arbitration and setting up of New Delhi International Arbitration Center and Mumbai Center for International Arbitration has specialized arbitration benches in high courts. It reflects institutional commitment. But institution alone didn't resolve disputes. Skilled arbitration practitioners do, and therefore this kind of competition is very important in my respectful opinion. And that is the place where all the students and the faculty who teach arbitration, their jobs, come in. So now I just want to add one topic, and the topic is what young lawyers must understand about modern arbitration, which is, I think, should be useful to all of you. First, abandon the notion of arbitration is litigated in light. It demands distinct competencies. When the Supreme Court in the Parkins Eastman Architects 2019 judgment held that the group of companies doctrine applies in India, it created opportunities, but also complexities around joinder and consolidation that demand sophisticated strategic thinking, which is very important. In Vidya Rolia case 2029, I would like all of you to read also all these cases if you want to venture into arbitration field. The Supreme Court laid down, this is Vidya Rolia's case, 21, comprehensive fourfold test for determining arbitrability. You must master this if you want to, enter into this practice, from intellectual property disputes post Erickson versus Intex to insolvency matters after the amendment of Section 238 of the IBC. The boundary of what can be arbitrated are constantly evolving. So it is actually increasing and evolving with all these judgments. The second point I want to make in this for the young lawyers, understand that Indian arbitration is increasingly international in character. The Supreme Court in decision of Indus Mobile to recognize emergency arbitrators, the acceptance of third-party funding in certain contexts, and the progressive interpretation of the seat versus venue distinction in BGS, SGS, SOMA versus Mankatsu Impex show India converging with international best practices. We had a problem with, Singapore commercial arbitration practices, but with all these judgments, we are trying to crease out the distinctions. So recognize India's technology transformative impact. The Gujarat High Court initiative on online disputes resolution, the increasing acceptance of virtual hearings validated during the pandemic, and the digital transformation of evidence management are reshaping that, the practice. Now, the question that everybody will raise, it is how quickly, because like we are doing this online thing, this we could not have imagined 4 years hence. Otherwise it was very difficult to do moot courts in our time because people used to travel far and wide. Now, with the advent of all these platforms like Zoom and all, and the advent of online thing, we are able to, connect and impart such kind of knowledge. And therefore, the court has, Gujarat High Court particularly, has recognized the online arbitration and the practice, and actually kind of validated the rules for the same, which is I think, step in the right direction. So I would not take much of a time. There's a lot to say. I have also jotted a lot of points, but I think it will take a lot of time. And Mr. Rai also wants to go. Therefore, I would only say and reiterate, which I've said in the morning, that you read the judgments, the recent arbitration judgments, get acquainted yourself. It's a growing field. We are working on expanding the horizons of arbitration in Delhi and also in Hyderabad, where new arbitration institute IAMC has come up. We are trying to expand it and take it to the level of Singapore International Arbitration Center, so that we also get a lot of international commercial arbitration, which would actually, benefit all the young entrants in the arbitration field. It's very paying field, like I said. We don't even have 5-7% of the, global share of the pie. So even in Supreme Court, next in line is the new Supreme Court building, where we have a very state-of-the-art arbitration center. We already have one in Delhi High Court. Hyderabad, I mentioned, it was inaugurated about 5 years back and is gradually picking up. So there's a lot in the field, and we hope that it'll be a great opportunity for all the young entrants, young lawyers who choose to join this field. And like I read few of the judgments, you go through all these judgments, acquaint yourself, equip yourself, and you will be all set for arbitration practice. And I'm very glad that you organized this competition. Like I said, all of us have learned. Thank you very much and all the best. Over to you, Manasi.
Thank you, sir, for that truly illuminating address, emphasizing that the highest form of advocacy often lies in finding a resolution. Ladies and gentlemen, we now have the profound privilege to welcome a true titan of the Indian legal landscape. Please join me in extending a warm welcome to Senior Advocate Pradeep Rai, sir. Sir stands amongst the most distinguished counsel at the Supreme Court of India, possessing a staggering 25-year tenure marked by brilliance and versatility. Designated a senior advocate in 2015, he is a master of the legal craft, navigating the complexities of civil, criminal, revenue, and constitutional law with equal command. Whether representing the union government, state ministries, or even high profile personalities, his litigation expertise is widely regarded as foundational to modern Indian jurisprudence. Sir's dedication extends far beyond the four walls of the courtroom. He is an architect of justice reform. He currently serves as the chairman of both the Indian Legal Research Foundation and the Indian Legal Aid Center, championing the cause of access to justice for all. His commitment to institutional excellence is further demonstrated by his role as Vice President of the Indian Society of International Law and his repeated service as the Vice President of the esteemed Supreme Court Bar Association. His career is a testament to integrity and progress. Sir has been a dedicated champion of prison reforms and recognizing the imperative of efficient justice. He is fervent advocate for ADR, having personally trained over 300 lawyers in arbitration. Sir, we recognize not just a legal stalwart, but a guiding force, a practitioner who upholds the finest traditions of the bar while relentlessly pushing for a more accessible and equitable justice system. Ladies and gentlemen, please join me in welcoming true luminary, Senior Advocate Pradeep Rai, sir. Sir, we humbly request you to address the gathering.
Professor Rakhi Singh Chauhan ji, Mr. Devbrat, dear friend, Mansi Gupta ji, Hariom Avasthi ji, Mr. Dr. Akshay Bhargava ji, Diksha Bhadoria ji, Jigyasa Bora, Richa Mittal ji, and the faculty, staff, and other members of your prestigious Institute of Management and Research at Gwalior, who have contributed immensely for this program and this event. In any kind of academic activities, when we pick a specific area in which we have to deal with in the bounds of a particular subject at that point of time, we have to deal it with the real cases. And it's good that you dealt with the real case. I will also give the example of 2-3 cases in which you will be able to understand in a better way. Recently, I appeared in a case, and that case was before the arbitrator. Arbitrator passed an interim order. This is the case where the interlinking of arbitration and mediation is there. The parties entered into agreement, rent agreement, in which they decided that there is a mall in Delhi. In that mall, a particular business area where is the restaurant is there, some other shopping center is there within that campus itself. So he entered into the agreement, both the companies, and they said that they will start paying the rent when will be occupancy of 45% of the mall. The purpose of this is that when the other person who is taking the property on rent, they have one particular point in their mind that unless there is enough footfall, they may not be able to get the benefits of the mall, and even this paying the rent will be difficult. The same with the mall persons. They also feel that once they have the good brands in the mall and they start getting good footfall, then their income can be much more. And the rent was subject to and preconditioned as if the mall is occupied by 50%, rent will be more. If it is 70%, rent will be more. So the business model is completely on the basis of other international standards. Unfortunately, the party which owned the mall, they entered into some dispute with the DDA. And because of that dispute, DDA cancelled the allotment. At that point of time, they had only 30% of the occupancy, so it was not 45%. So they did not, the parties who were occupying the mall, they did not pay a single penny. And the owner of the mall had to pay everything. They have to maintain the mall, and it causes severe loss to them. After a period of 2 years, they thought that this litigation is prolonging and is pending before the High Court. So they redrafted molded the terms of the agreement. And because of that molding, they say that even if 30% is occupied, parties will pay the rent, but they reduce the amount of the rent. Unfortunately, when they entered into this agreement, one major brand, Pantaloon, who had occupied around 9% of that 30%, they also left. So again, 30% was not covered, so they were not entitled to collect the rent. They went to arbitrator, and this concept is very new, that somebody is occupying the mall, utilizing it, but not paying you a single penny rent. But because of the terms stipulated in the agreement, they were not entitled to get the payment. Ultimately, arbitrator passed an interim order that at least some maintenance part has to be given by the parties, and parties challenged it before the High Court. They said, no, nothing doing, we will not pay a single penny because the agreement says so. And then we requested them to enter into mediation. And then they started mediation process. In the due process, parties agreed that they will be paying only 20% of the rent, and the part maintenance will also be borne by both the parties, even the small owners, shop owners, and other persons who have occupied it. And gradually this matter is settled with a condition that whenever this mall qualifies to collect the rent and 30% occupancy is there, they will start collecting it. So in arbitration, it was not possible to settle it. So they wanted to force them for the eviction. They said, even you can't evict us, because the primary condition you do not qualify. An agreement is valid for a period of 10 years, but there was a clause of re-extension and renewal of the agreement for every 11 months. So first party says that we have invested this much in construction and designing the shops, so you cannot throw us out. Other parties say that you have invested so much, but you are occupying it, we are paying the maintenance, and you are not paying us a single penny. So finally, this was settled in mediation, not in arbitration. Arbitration award was pending. Arbitrator said that you pay maintenance. Even still, it was not sorted out, and multiple litigations were there. The problem is that whenever you have these kind of matters, and if there is a delay, it causes severe losses to both the parties, because there is uncertainty. And uncertainty will cause block you, or they will create impediment to invest. I will give you another example. I was court commissioner for the road projects in Nagaland. The government of India, NHAI, they had granted a kind of big contract to two companies to construct the road which is connecting from Guwahati to Dimapur, Kohima to Imphal. So that road was supposed to be constructed, and they were supposed to pay. So normally what happens that whenever there is a road projects, the parties do not include the earthwork, cutting of the mountains, cutting of other things. And unfortunately, depending on different states, the cost of the per kilometer of the road is different. And I am not able to understand this so far, because if it is a hilly terrain, cost has to be more. but governments pay less. That is around 5 crore, 6 crore per kilometer. Again, if you go for some plain area, sometimes you see it's 25 crores or 30 crores. So all these discrepancies may be there, but ultimately the parties who were assigned to construct the road, they completed 20% of the work. They had taken loan, and upon taking the loan, they were constructing it. So suppose if NHAI or any other authority who had assigned them this work does not pay them timely, and later they pay the same amount, then the bank interest rate is so high that the cost of the project will go almost 30 to 40% up, because you have taken loan and you are constructing, so you have to pay the interest to the bank. And if government doesn't pay you on time, your project will be in the loss. So you will not go for a loss-making project. That is the problem. And then ultimately, you see that there are so many nitty-gritties involved. We all have read the story called Merchant of Venice. Most of you must have read it. So ultimately, what happens? That when you see and when you say that there are a precondition that if you do not comply with the agreement, I will take so much flesh from your body. And because of these terms that you have to cut his body and take the flesh out, because of animosity, you say, no, I will take flesh only. And fortunately, the other character says, yes, you are right, you may take the flesh, but there should not be a single stain of the blood coming out. The moment blood comes out, you are breaching the agreement. So fortunately, they were saved. Same with the law. Whenever you apply a particular rule and regulation, normally it is expected that it will follow the way it is. But everything is not the way it is. There are so many unforeseen facts and circumstances prop up which you do not realize at the time of signing of the agreement. Each and every party, when they enter into some agreement, they are cordial. They all feel business. There are very few persons who do not do this. As far as India is concerned, unfortunately, we started very late. India International Arbitration Center was without any chairman for a long time. Recently, Justice Hemant Gupta, who was former Supreme Court judge, has been appointed. And now they are taking this job seriously, but other countries have already taken a lead. Then there is absence of independent arbitrators. Like suppose I tell you that now so and so person will decide this matter. And you know that so and so person is very close to the other party. You may not accept it. In India, the parties normally, they decide that the person who have granted you contract, normally they put this term in the agreement itself that they will have exclusive right to appoint sole arbitrator. And appointing sole arbitrator means that they will decide the matter accordingly and they will keep getting the work and assignment. That part is now being settled. Now there is a scope of having the independent arbitrators, and then there is a delay. The judges who are busy, they are so busy that they give even the arbitration date after 3 months. So the purpose for which this tribunal was created, that there will be speed. So there is no speedy justice. See Singapore, see London Center, or even this Dubai Financial Center, you will find that the judges who are appointed there are in international reputation. And when they have the international reputation, you will not have any suspicion in your mind. So we all have to see all these things. Young students, you all must be reading newspapers. And if you are not reading, you must read. Because many of the law students and interns who come to my office, I ask them few questions, because you have to be legally aware. You are not just a student of management or maybe medical or science or something. Law is the only area where your each and every experience counts. Suppose you are in a profession of engineering, or you may be a doctor. At the age of 52 or 55, you decide to join the profession of law and you start practicing. Your entire experience as a doctor or as an engineer will not go into vain. You will use that. So this is the only profession where you, whenever you start, your earlier experiences are also part of it. And one more advantage is there, that if you don't want to work, you don't work. If you want to work, you work. But hard work is there. Nothing you can get without the hard work. I do not want to make the speeches, but the only one more story I will tell you. Like Munshi Premchand's story, you must have heard, the Panch Parmeshwar. He had written when two friends, they were fighting. They're very close friends, but they started fighting for some reasons. The one friend was Algu, other was Jumman. So originally, one friend, Jumman, he was harassing his grandmother, who had given him properties and all. So she went to the Panch, and the Panch decided, the Panch was nominated. Dadi said that, okay, I am appointing your friend Algu as Panch. He will decide, he will take a decision that whether you are right or wrong, because I have given you all my properties and you are not taking care of me. So Algu decided in favor of grandmother, and he said, no, Jumman has to take care. Later, Algu had two bulls. He gave one bull to one local businessman who used his bull, and his bull died. And when he died, he again approached the Panch. The businessman appointed his friend Jumman as Panch because he thought that there is some problem is going on between these two. So he will succeed in the matter. And Jumman had stopped talking to Algu because he thought that this man, despite having so close friendship, he did not decide the matter in my favor. So when Jumman started hearing this matter, he started crying and he decided in favor of Algu. And when Algu asked, Algu also started crying because he was helpless. He thought that now this matter is going against me. But when he got the judgment, they hugged each other, and then both of them cried. He said, why you were not talking to me? He said, the job of judge is very difficult. It doesn't mean that there is no corruption in judiciary. I am not defending that. I am saying that if you are genuinely, if you feel the way they felt, the common man, or even the people still have faith in judiciary. You see, anybody who has some dispute, they say, court mein dekh lunga tumko. So we all have to be, in that sense, we have to be very accommodative. For the business also, when the parties come to you, most of the young lawyers, if you say that you should not fight, you should do that, then you are losing your client. But ultimately, there has to be a solution. And there has to be a rule of law. If parties know that if this matter goes to arbitration, the party who is right, they will succeed. So many of the cases will not be contested. We all, Indians also, many countries, we know some jugaad. Jugaad means when there is something, we can find out some way. And that way is not appreciable. When there was a judgment, 5-6 years back, a friend of mine has delivered, in which he had written that both the parties who are contesting are on trial. They know the truth. They know who is right, who is wrong. It is the judge who is on trial. So all these things are there. All these young minds who have participated in this competition, I really appreciate. It was really very difficult for us to judge because all of you were so good. All of you were so well trained. And with the company of wonderful faculty and such kind of zeal and enthusiasm, they all tried to organize this program. I want to really apologize to Mansi ji and Professor Rakhi Singh ji, because I had to attend this program physically. Because of our Supreme Court retirement, even today when we are having this conversation, I am missing a lunch. Because when judges retire, there are so many things happen. Devrat ji also, he is supposed to go, I think. He is also getting delayed. But that doesn't matter. These things gives us a kind of pleasure, a kind of satisfaction. And I am really thankful that you invited both of us and to have the interaction with the wonderful persons. Devrat ji was very much involved. He actually noted the questions when we discussed. He had very good command over the entire discussions. And what we see, we do not see that whether you had addressed the issue in which the facts were granted to you. Your conviction, your confidence, the way you have dealt with the issue. And I cannot finish my address unless I appreciate Asi Mangal. She's a wonderful girl. I think that she's a student only. She's a student only, I think. So she has created the video and sent it all to all of us. You see, the students should be doing everything. If you are participating in sports, you must participate. You should not close it. If you are in cultural program, you must participate in that. Because our profession is not only one part. You have to appear for a filmmaker, for a dancer, for a musician, for an anchor, for a IPR case, or even fashion case, or for a weaver, for a doctor, engineer, anything, for an airlines, for air hostess. So whatever you do, whatever talent you have, especially the law students, you should not close it. Even my own family members, sometimes they say that we do not want to pursue law. I am the first generation lawyer, first person in my family who joined this profession. I am the first person in my family who visited any city. None of my family members have ever visited any city. So English also was not a very good subject for me because I started learning from the class 6th. And law also, LLB also, I did in Hindi medium. Later, we had to work hard, and ultimately, we are doing whatever we can do. Why I'm referring this? Because if I can do something, if I can achieve something, despite all the adversities, why you all will not achieve? You all are at better footing than me. And you all will certainly achieve much, much more than what we have achieved. So my best wishes, congratulations to all of you. And again, a big thank you to everyone for giving me this opportunity to interact not only with the students and the faculty, but also to my dear friend Devrat, who is otherwise very busy person. He can be seen in the courts only, otherwise he is not approachable. He disappears very fast. So it's very good that we all had this good time. Dr. Hariom Awasthi ji, Acha ji, and Mansi ji, Dr. Rakhi Singh ji, and all these, even Jigyasa Bora ji, all of you, I give a big thank you. Thank you, Kartike. Thank you, everyone, for this wonderful program. And who has succeeded in this competition, they should not feel that they were the best. Today, it was their day. Who did not succeed, they have a chance to improve. So don't bother on this. You participated. That itself is a success. You all left a mark on us. And I really appreciate such a wonderful program. Thank you so much. Thank you.
Humbleness is truly inspirational. Thank you so much for recognizing each and everyone's effort. And thank you for your powerful insights on the necessity of institutional reform and the future of ADR. And also, sir, thank you so very much for telling us and inspiring us and telling us that individuals from every profession background can bring and begin practicing law, and the diverse experiences they bring only enrich their journey in their legal field. Thank you so very much, sir, for your presence. We have been educated, inspired, and deeply moved by the words of our distinguished guests. Now we arrive at the moment of truth that every participant has been eagerly waiting for. The time has come to honor the diligence, the strategy, and the brilliance displayed over the last 3 days. May I request our principal, ma'am, to kindly announce the results. Ma'am.
Thank you so much, Mansi. I know the most awaited time has come now. So the winner of this competition, the award goes to team number TC005 Mahindra University with a cash prize of rupees 25,000, trophy and certificates of merit. Congratulations, Miss Shruti Kirthana and Goteti Kumari Sai Gayatri. The runners-up prize goes to Indore Institute of Law with a cash prize of rupees 15,000, trophy and certificate of merit. Mr. Ankush Sharma and the award of best draft goes to again Indore Institute of Law. They are going to have party today. Ankush Sharma and Saksham Goyal. And the best presenter goes to Piyush, TC020, University Institute of Legal Studies, Punjab University, Chandigarh, with a cash prize of rupees 10,000, trophy and certificate of merit. A big congratulations on behalf of Prestige Institute of Management and Research, Gwalior Department of Law.
Thank you so much, ma'am. Congratulations to all the winners, runner-ups, and every single participant that has come forward and participated in the event. The tenacity you showed is the true award. I would also like to extend our heartfelt congratulations to the core team, whose tireless effort and sharp acumen made the execution of this entire national event both seamless and successful. Naming student convener Mahima Maheshwari, student co-convener Ashi Mangal, student co-convener Kartikeya Saxena, secretary Aniruddha Gupta, joint secretary. Every successful event is a collective effort powered by the generosity of time, spirit, and dedication. To formally express our sincere appreciation to everyone who has contributed to this momentous competition, I would now like to invite Dr. Hariom Avasthi sir, Associate Professor, Department of Law, PIMRG, to deliver the vote of thanks. Sir, over to you.
Thank you, Mansi ma'am. Honorable Director, Professor Dr. Nirmalya Bandyopadhyay in absentia, Honorable Principal of the Department of Law, Professor Dr. Rakesh Singh Chauhan ma'am, esteemed guests for the occasion and arbitrators for the final round, Advocate Dr. Pradeep Rai ji, Senior Advocate, Supreme Court of India and Vice President of Indian Society of International Law, and Advocate Shri Devvrat ji, Advocate on Record and Senior Mediator at the Supreme Court of India, all the distinguished dignitaries, faculty members, participants, and dear students, good afternoon to all. It is my privilege to extend the vote of thanks on this momentous occasion, marking the successful culmination of the 3-day Prestige National Arbitration Competition 2025, the Pathway of Resolution, organized by the Department of Law, Prestige Institute of Management and Research, Gwalior. Over the past 3 days, we witnessed a remarkable exchange of ideas, arguments, and arbitration skills. This event not only aimed to introduce law students to the nuances of arbitration, but also to help them understand how alternate dispute resolution mechanisms can effectively address the rising burden of pending cases. At the outset, I express our deep gratitude to our respected Director, Professor Dr. Nirmalya Bandyopadhyay, for his constant encouragement, institutional support, and visionary leadership. We also extend heartfelt thanks to our respected Principal Ma'am, Professor Dr. Rakesh Singh Chauhan, for always being there as a teacher, preacher, and believer, and for mentoring legal minds through her insightful observation, and guidance. Thank you so much, ma'am. This competition was strengthened by the presence and expertise of our distinguished arbitrators across the preliminary, semi-final, and final rounds. We sincerely thank Advocate R.H.A. Sikandar, Advocate on Record, Supreme Court of India. Advocate Amit Dwivedi, Advocate on Record, Supreme Court of India. Advocate Sandeep Jindal, Certified Mediator ADR. Dr. Ankita Khanna, Certified Arbitrator and POSH Trainer. Mr. Mehul Bansal, Founder and CEO, Talon Advocacy and Mediation. Advocate Tufail Sharif, IIM Accredited Mediator. Ms. Geetika Jain, Academic and Alliance Manager, Manupatra. Advocate Ujjwal Sharma, Advocate on Record, Supreme Court of India. Advocate Akarshi Jain, Advocate and Arbitrator at Sama Admin Team. Their insightful evaluation, constructive feedbacks, and professional guidance have played a pivotal role in shaping the learning experiences of our participants. We extend warm congratulations to all the winners and all 22 participating teams from across India. Your enthusiasm, preparedness, and commitment added energy and substance to this competition. Each round reflected deep research, advocacy skills, and teamwork. Whether you win or not, your participation itself makes you a part of the enriching journey. Events of this scale are not possible without dedicated teamwork. I place on record our sincere appreciation to all the faculty members of the Department of Law who conducted technical sessions and ensured seamless organization. Assistant Professor Ashish Yadav, Assistant Professor Abil Hussain, Assistant Professor Rahul Srivastav, Assistant Professor Mansi Soni, Assistant Professor Jigyasa Vohra, Assistant Professor Dr. Diksha Bhadoria, Assistant Professor Richa Mittal, and Assistant Professor Sahil Verma. A special note of thanks to our convener, Dr. Akshay Bhargava sir, and co-convener, Ms. Manasi Gupta ma'am, for their tireless efforts, planning, and commitment that ensured the smooth execution of every round. Lastly, I thank to all the students, volunteers, supporting staff, and every individual who contributed directly or indirectly to making this national arbitration competition a grand success. With all these warm words, I express our heartfelt gratitude to everyone present over here. Thank you all for your support, participation, and goodwill. Jai Hind, Jai Bharat.
For those sincere words of acknowledgement, we thank our esteemed guests of honors for their invaluable time and wisdom. We thank our principal ma'am for her vision, and we thank the organizers and volunteers whose tireless efforts made this national success possible. The curtains may fall on this session, but the journey towards legal excellence has just begun. Thank you all for being here today. Jai Hind.